બધા બે બાકી નથી. 2-3 સાક્ષી ને પછી પોલીસ વાળા. આ સાજે સાક્ષી છે અને આપણે જે લીધા નથી. ના નથી લીધા. અધૂરી ઓપન જ કરવાનું. 5 માર્ચ
સાહેબ વિનંતી કરી દઉં સાથે કે ક્રિમિનલ અપીલ 4 નંબર છે. મેં ક્લાયન્ટ ઇઝ પ્રેઝન્ટ પૈસા મેં અગાઉ ભરી દીધા છે. આવતી મુદત એવી રાખો વિનંતી સાથે. પેલો લોક અદાલત તો હું પેલા મીટરના જજમેન્ટના આધારે હું સાહેબ અરજી આપી દઈશું. લોક અદાલત ચલાન રાખો ને તો ફેબ્રુઆરી 23 ભલે હાઈ લેવલ મેં ક્લાયન્ટ ઇઝ પ્રેઝન્ટ
सेशन 407/18 गोवर्धन भाई परमार वकील श्री सीआर वाघेला सेशन 9/21 बजरंग सिंह
વોરંટની બજાવણી સંદર્ભે શું કાર્યવાહી કરી છે તેનો રિપોર્ટ રજૂ કરવો. હાજર રહેવાનું ન કરતા.
सेशन 217/21 वकील श्री पीएस साहब वकील श्री एमबी सतवारा सेशन 41/22 ત્રણ આરોપીને નોંધણી કરી છે એ પ્રોસિક્યુશન ફરિયાદીના સાહેબ આવે છે ફરિયાદી ભાવેશભાઈ સાહેબ પ્રીતિબેન આવે
પ્લીઝ
12 માર્ચ
પ્લીઝ
सेशन 70/22 दीपिका वकील श्री AR दवे
नंबर में ले ले
सेशन 102 તમારે બતા 12
એક બે એની મેટર આર્ગ્યુમેન્ટ માટે છે ફાઇનલ આર્ગ્યુમેન્ટ
सेशन 172/22 लावाती नंबर 1 ની એક્ઝામ્પશન છે બે નાગરિક છે એલન છે નાગરિક
મુદ્દામાલ માટે છે મુદ્દામાલ માટે લેટર કરનાર પોલીસ સ્ટેશન ને અને પીઆર ના એપીપી ની જાણ કરવી
12 માર્ચ
પ્લીઝ
સોરી 13 માર્ચ
આમાંથી
सेशन 134/23 वकील श्री अजय पटेल चार बनसो
बजट से आरोपी बाकी પછી હાજરી પૂરી દેજો બધાને. વકીલ પણ હાજર થઈ જવું જોઈએ. એક્ઝામ્શન હોય તો એક્ઝામ્શન લઈ લેજો.
NIA 3/20 વકીલ શ્રી LR પઠાણ. વકીલ શ્રી LR પઠાણ.
હા જોઈને પછી મારે મુકેશ કાપડી હાજર થઈ ગયા. મુકેશ કાપડી બધું વકીલ બદલાવા મુડેકની તારીખ જોઈએ. જી સર 3/20 ને 3/21.
વકીલ શ્રી LR પઠાણ. વકીલ શ્રી LR પઠાણ.
થઈ ગયો ને તો થઈ ગયું. શેખ ને કહી દો. શેખ
વકીલ શ્રી MM શેખ.
જાણ કરાઈ દે ને. યુપી ની સાક્ષી એમાં સાક્ષી છે ને યુપી થી આવ્યા છે. લઈ લો તો એને લઈ લઈએ આપણે. હું લઈ લઈશ. હા એને લઈ લેશું. લઈ લઈશ. અને કદાચ આરોપીને બોલાવે તો બોલાવી લે. જો હું ફોન કરું બહુ દૂર ના ગયો તો બોલાવી. નહીં ગયા હોય લઈ લઈશ.
Serial number 17 4/7/18.
હા
એમાં ડી બાકી છે. serial number 22 તો મુદ્દામાલ બાકી છે.
કઈ સિરિયલ નંબર
વકીલ શ્રી LS પરમાર. વકીલ શ્રી LS પરમાર. ડોક્ટર આયા છે પણ આ બધી પ્રોબ્લેમ
જવા દો એપોલો હોસ્પિટલમાં એટલે એમને બી કન્સલ્ટ
જવા દે.
હશે. થઈ ગયું.
દસ નંબરમાં છે એમ્બ્યુલન્સ. લાવો ને જાણી. માં શું છે 405 2024
405
બોલો વોરંટ ના
એ
આધારે
વોરંટ ના આધારે છે સાહેબ. આપ સાહેબ
કન્ડિશન કઈ મૂકીશ
દર મુદતે હાજર રહે સાહેબ.
આજે રહેવા માટે કન્ડિશન તો અત્યારે
એરિયા છોડે નહીં.
અશ્વિનબેન બોલો ये तो आ गया 88 वाला। कैसी हो गई तभी का बराबर है। तुरंत ना बैठे तब छोटे उसमें पकड़े और कभी कभी छोड़े कंडीशन छोड़ कर
Yeah, UAP and the NDPS Act. But first, I'm dealing with the NDPS Act only. Before I will go through my lord the evidence, relevant evidence for the purpose of those are by this time, by numbers of the judgment of the Supreme Court and our High Courts have decided that these are the mandatory provisions which are required to be followed.
Yes.
Now, amongst them, the mandatory provisions is Section 42. I will just read, my lord, the Section 42, and then I will proceed to show the evidence in respect of this compliance of this 42 and 42.1.
42 and
42.1 and 42.2. So 42.1, I'm just reading.
yes.
Any such officer being an officer superior in rank to the peon, sipai or constable, to the Department of Central Excise, Narcotics, Custom, Revenue Intelligence, or any other department of the central, including the paramilitary forces or armed forces, as an empowered on this behalf by the general or special or by the central government of a such officer being an officer superior in rank to the peon and sipai or constable is being an officer superior to the rank to the peon or sipai or the constable of of a revenue or drugs or control or excise, the police or any other department of the state government as an empowered by on this behalf or by the general or specific order of the state committee, it has been reason to be believed for the personal knowledge or information given by any persons and taken down in writing. I'm emphasizing these words only on that having empowered in this behalf, empowered in this behalf by general or special order of the state government has reason to believe for a personal knowledge. So some information from his personal knowledge, yes, we see it. Or information given by any person and taken down in writing that any narcotic or seizure substance or the controlled substance in the circle which an offense is punishable under this act has been committed, or any document or other article which may be furnished evidence of that commissions of such offense, or illegally acquire the property or the document or other article which may be furnished evidence, hold any illegally acquiring the property which is liable to be seized or freezing chapter so and so, and this act and kept it concealed in any building, conveyance or closing. He can, before sunset, he can that enter into such building and conveyance and places I'm sorry, I'm reading the 42 one. 42 to 121. Then the right had been given to him. Then proviso that in respect of holding the license of the manufacturing drugs of they આપણે સબ લાગુ નથી પડતું manufacturing માટેનું. Providing further that if such officer has reason to be believed that the search of the warrant authorized cannot be obtained without the affording the opportunity to the concealment of the evidence of the facility for the escape of the offenders, he may enter into such and such buildings, conveyance or. Then second, where an officer take down any information in writing under subsection 1, recorded the grant of his belief under the provisions thereof, and shall within the 72 verse copy sent to thereof to be to the immediate superior officer. So this provision provides two things. That if he has reason to be believed, if he has reason, have information, first he has to take down that in writings. And provision 2 provides it that it should be sent to his immediate superior officer within 20, copy of that to within 20. And these provisions had been held by members of the college as mandatory provisions that I will be touched at the time of my submitting my judgment. I will show that these are the mandatories. Now, in this respect, particularly this 42.1, 42.2, I will be just reading the evidence which had been come on record. The PW number 1, he is the principal additional directors. Now, his evidence so far this 42, 41 and 2 are concerned. I will be read only relevant, but his evidence is entirely relevant for that purpose. But the evidence of other witnesses are to some extent. So I will be read the portions of, relevant portion only.
Exhibit?
That is exhibit number 45.
45. Yes. So from this evidence, you want to point out
You see,
that there is a breach
entire
of-
evidence is important for the purpose of, deciding the issue. So far, 41 to 41 and 42, 1 and 2 are concerned.
41.
41, I may read some. 41, I will also read 41. So it will be, so for the, that is difference between the officer.
Yes, yes.
I may just reading my lords. Power to issue the warrant authorized. Any metropolitan magistrate or magistrate, no, 41 is not that. But the 41, 1 and 42, the difference, my lord, is this. I may say, 41 provides that
for getting the warrant.
no, the so far the information is 41 is for the getting the warrant. But 42, 1 and 42.
42, 1 and 2.
The difference is 42, 1 is that if the officer who received the information above the cadres,
Mentioned therein.
above the cadre of Sipai, then he has not to comply with the provision of 42.2. He is not required to send the copy to his immediate superior officer. That, but he has to reduce in writing. That are that. So far, those who are below that categories, then they have to not only reduce into writing, but to have informed to the immediate superior officer. So this way, there is a distinction between these two. Now, for this purpose, I am reading the evidence of this VPW1 Exhibit 45.
Yes.
In the year 2019, I was the posted in the additional director of the Central Direction of the Revenue Intelligence as at Ahmedabad. Now, as I said it, he comes within the authority, revenue officers are also included. In charge of the Gujarat, my job profile, including the handling and intelligence and executions thereof pertaining to the Custom Act, NDBS Act, and all other allies act. In the month of May, this is the information according to him. In the month of May 2019, I received a credible intelligence that a Pakistani fishing boat carrying a narcotic drugs was waiting for last many hours at a particular GPS location in the sea to deliver the drugs to an Indian fishing boat, which was to receive the drug and to bring in India. Now, lastly, I'm just posing for a moment over here. For a moment. These informations, according to him, who received it, he has not disclosed it. It is not that he said that I have received that information. He says, I'm reading. I was posted at that time the charge of the police officer, including intelligence officer pertaining to custom and other allied officers. In the month of May, I received the credible information. Yes. Now I'm posing it because subsequently it will come. Yes, it will come subsequently. So here he coming with the case that I have received an information. Let us take as it is. In the May 19, he is not giving any date for me. Yeah, Anna, maybe just because reading these sections 40 to 1. The time he received the information, he has to reduce into writings. So that including the date on which, at the time at which he has received the information. So he did not disclose the date on which he has received the information. Now, this information is this type of, okay, some Pakistani boat is coming with the narcotic drugs and going to be supplied to the Indian fishing boat. That is the information. There was possibility that the said Pakistani fishing boat may try to enter the Harami Nala or Shir Creek. As requested, my counterpart in this Coast Guard and BSF to intercept the said boat had taken further necessary action. I'm again posing here for the moments. So, admittedly fact that Coast Guards are keeping a watch on a sea area. BSF is a border security. They are on land working. So when he is informing these informations, both to the Coast Guard and BSF too, meaning thereby, he is not sure as to which place the narcotic substance is to be given to somebody as to deliver. The said boat had taken further necessary action. I sent the fax message immediately as the speed post letter. I am being shown that the letter produced Annexure B, volume page 437, which is true copy of the Coast Guard, the Inspector General, BSF Gandhinagar by me, and also bears the signatures identifying the same, that is Exhibit 46. Now I'm taking my look at the Exhibit 46 itself. Yeah, 46, my lord, on page 347 of 5B. This fax message, the heading is a fax message and a speed post both. And to the two authorities, the Inspector General of the Coast Guard and the Inspector General of the Border Securities. To both he has written this letter. This letter is issued on 28th, this date is important, 28th of May 19. credible intelligence indicate that Pakistan fishing boat carrying narcotic drugs in the GPS location so and so and so and so since last many hours of today, namely V-90. It is waiting for an Indian fishing boat that is received to take the delivery mid-sea and then to bring the drugs into India. The possible that the last few hours, the Pakistani fishing boat may have entered into Haraminala or Syria. Now, this is the information is vertically same. Again, vertically, the information is the same. I'm not disputing that thing. But again, your Honor will be fine in this letter. That he did not disclosing in this report that it was information he has received. One thing. Word had been used, credible intelligence indicates. I will be coming across him and make this issue clear also. But he has not made it clear that it was he received the information one. That also it is on what day the information received is also not there. Now, so far this letter is concerned, Your Honor, maybe see because I was to discuss this issue or almost all the document which was to be produced. May I keep that my argument reserved, but just to bring to your Honor's notice that evidence X provides the document must be placed original. One. If original is not available, then on giving explanations of loss or destroy of original one, you can produce the copy thereof as a secondary evidence. As a secondary evidence. Now, this is neither the original, that is the office copy. One. Two copies are there. One that I am writing it, so I am keeping one office copy. The second I am writing to some authority, that is the received by them is the original one. So either the original one or when you are producing the office copy, then you have to produce also the evidence regarding the sending of, that it was sent and received. That evidence you have to adduce it. If you are relying on a document which had been received by the, to the addressee, then that document will be admissible in. But though that document in almost all documents is in respect of all documents, I will be say read the evidence section. I will argue that part also. But in all the cases, all the documents, the original are not coming on the record. First, secondary, no document is coming as a secondary evidence, as provided under the evidence, and therefore, because this is an attested true copy, and therefore the document itself in view of the Evidence Act is not admissible. But otherwise also, non-indicating as to he received the instruction and what day the information has been received is a clear breach. Even if presuming that this had been written down, even if presuming it is written down, then also it is the breach of 42(1). Now I will be read the further is cross-examination on this aspect. Only relevant portion I will be reading, Your Honor. On page 3 of his deposition, para 3, second line.
Yes.
I do not require any permissions from any authority. Your Honor, got it?
Yes.
Then before 2019, the information letter exhibit 46 was received by me. If he has received the information, there cannot be receiving of the very information, meaning this by that it was not received by him, but somebody else who forwarded to him. Because the clear terms he is admitting before 2019. Even not in May, January. This had been happened in the May 2020, May of 2019, the letter has been issued. That information he has received prior to 2019, that is in 2018. I cannot disclose the same. Before 20th, 5th, 1999, I cannot disclose the same. Under what provision he claimed and the right to conceal that document, which ought to have been common record. Before 25th, 1990, we have started the proceedings. This is also important. Before 28th, 5th, 19, we have started the proceeding for the information we have received, exhibit 46. Meaning, this is against indication of it. That what information had been received by him is before 28th of March 2019. The proceeding which was started before 2019, the department were done orally and by document. For the procedure, we have started, I'm not reading that, but it's not important. So then after leaving 4-5 lines, I cannot disclose the name of the agency. The agency which worked with me, I cannot disclose the name of the agency. The letter exhibit 46, which was sent by fax message, was sent by my department lower officer. The lower officer of my department who sent the fax message, I do not recollect the name of that lower officer. Even I cannot say the time on which the fax message was sent. I do not recall at this juncture the receipt showing the fax message sent. The letter exhibit 46 was prepared by our office. I cannot recollect the name of the officer who prepared the letter. The original exhibit 46 with the BSF and the Coast Guard. So if you read all these things, the agency which worked with me, I cannot disclose the name of that agency. I cannot disclose the name of the agency. The letter of exhibit 46, which was sent by the fax message, was sent by my department to the lower officers. The lower officers of my department was sent to the fax message. I do not recollect the name of that lower officer. Even I cannot say the time on which the fax message was sent. I do not recall the so and so. Now, exhibit 46 was prepared by our office. I cannot recollect the name of the officer who prepared the letter. The original of exhibit 46 with the BSF and the Coast Guard. Now, the Coast Guard and BSF both have examined in this case. The officer from Coast Guard and board. None of them has produced the original of the 46. And the office copy is in my file of the office file. So this is also not the office file. This is not the also office copy. That is also at his office. The officer who had attested the certified and had done the true copy of the exhibit, I cannot say the time on which they attested was them. I do not understand. But it cannot be true. It is not true that I cannot say whether the original of exhibit 46, it is not true and correct that the information is received by me. It is not true and correct that the information of exhibit 46 received by me. Now this is admission in his part. Clear cut goes against his own statement in a chief examination that I have received the information. He said that I have received the information. Whereas he here in a clear term admitting it is not true and correct that the information of exhibit was received by me. So it was not he who has received the information. But otherwise also if we read entire evidence, it now para 4. Originally the information was received by my junior officer. Now he is coming here. The first information regarding this offense had been received according to him by his junior officer. I do not wish to disclose the name of that junior officer. Considering the confidentiality and secrecy, I do not wish to disclose the name of the junior officer. I'm just I'm proposing a moment. Had this given any protection to them that they cannot disclose? When the law itself is very much clear, the statute provides that it is the person who received the information at a first point of time has to take it down in his own right. Now, this is, he said that it was a junior officer, but he don't give the name of a junior officer. Lastly, may consider this aspect in this sense only, that protection had been given to police and all officers, not to disclose the name of the informant. That I can understand. They are not bound to disclose the name of the informant. That can be secret. That right is there. But you can't say that the person who received the information, his name also cannot be disclosed. In the name of the confidentiality or the secrecy, you cannot conceal the name of that person. Agar je sab ek witness आवसे, he has disclosed the name also. It is true that whatever the information was we received, the same related to the narcotic substance, we have to follow the procedure of NDPS Act. I do not wish to disclose the date on the time on which the information was received by my junior officer.
Yes.
Considering the confidentiality and the secrecy, I do not wish to disclose the time and the date of information received by my junior officer. Our department is maintaining the inward and outward register. I do not recall the name of the person who was maintaining the inward and outward register at that times. That is for the purpose of, I have asked this thing more particularly to read, if we go to the 46, if we look to the exhibit 46, because so for the facts is concerned, I can understand. But so for the speech post letter is concerned, it is the all government officer, and I will become to evidence, they will also admitted that all the letters which you are going outside should bear the outward register number. this letter does not bear even the outward register number regarding the posting that it had been sent. Similarly, the officer who is receiving in his office, there also it will be registered as inward register, and the letter will bear the inward register number.
Yes.
So, no evidence is coming on a record regarding the posting of this letter. Admittedly, original is not there. Admittedly, they are not coming with the case that it is the document we wanted to refer it as a substitute to that original one. That also not. They are producing this true copy. We do not know. The original, he admitted the original is with the person who received. The office copy is with me. Then what is wrong to produce the office copy before the Honorable Court? Why the true copy? And admittedly, there is no evidence of posting this letter or sending this letter, even either by fax or by speed post. There is no evidence. And therefore, there is reason to be believed, more particularly reading that evidence, that since prior to 2019, there were investigation this thing, indicating that this is subsequently created by the authority. Now, in this respect, the last 4 lines of the page 4 of his deposition on para 4, I do not know the whole procedure of the maintaining the inward-outer register. It may be possible that at that time, the post of the clerk of an inward-outward register might be vacant, and I do not recollect fully. See how a lame accuse had been forwarded. For not bearing the outward register number, he tried to make an explanation that probably the post of that outward register clerk was vacant. So there might be somebody who has been entrusted his job. One cannot say, one cannot believe it, that the official duty which is right to be performed for the purpose of, my lord, the transparency in the official duties, transparency, for the purpose of showing the transparency. Somebody else can be appointed. Somebody else might have on that day been given the charge of that clerk. But you can't say that it was vacant, and therefore nobody is not required to be registered. So this is absolutely lame accuse had been forwarded for the fault they have committed in it. The outward numbers on the letters are put by the concerned officer clerk who dispatched the letter. It is to, on the next page, I am reading, my lords. Next page,
Yes, yes.
para 5, or page 5. You bear the file number. The file number shows that particular event. It is true that 46 does not bear outward number. Then after leaving some 4 lines only, I cannot say the name of those witnesses who helped during the investigation. I am not concerned, but that will not be concerning Shobha 41, 42. Then para 6 on bottom of page 5. It is true that the office copy of Exhibit 40 is not with me. So he is blowing hot and cold both. On the one hand, he said, I received the information. He said that the office copy is at my office. Now he is saying that no, the information was received by my junior and the office copy is not with me. It is true that the office copy of the Exhibit 40 is not with me. And I mean, and I will produce the office copy of the exhibit for. There is no reason for not bringing the office copy of the with me. As I am coming from Mumbai, I was aware about the depositions of the fact regarding 46, which procedure the same at the earliest. Now, in this respect, very respect, if we read the evidence of PW number 2, exhibit 48, he was the commanding officers of the RNJ ship.
PW2.
PW number 2, my lord, page 48. Sorry, exhibit 48.
PW2 છે. Yes.
Is his paragraph 2 of his deposition, page 1. Ship RNJ sailed from Oka on 18/5/2019. At about 20:30 hours, it reached the national IMBL, National Marine Line boundary line, on the early hours of 19th May 2019. While on patrolling on 25th 1919, at about 18:53 hours, I received a call from the regional head office, Gandhinagar, on FDB feeding broadband by CSO OPS regarding the suspect delivery of the narcotic by the suspected Pakistan fishing boat in position of 279 methapods light, and the position बताएं, the ship altered her course and reached quantum of. This is very important for the purpose of information. Again, for two purposes. For two purposes. That this PW number 1 is coming with the case that wide exhibit 46, the Coast Guard had been informed, as well as BSF had been informed. Wide exhibit 46. So this is informed by facts and by later and by speed post. Two mode of information had been provided. Now this fellow is coming of information by neither of these mode. Neither he has said that I received the facts, nor he is coming with the case that I have received the speed post. Since he was on a high sea, I can believe it. A speed post cannot be received by him. Since he was in high sea, on 29, according to his evidence. But the fax messages, certainly it had been received by him. So fax message which is received by him is one of the best documents regarding that information received. But he is coming with the other case, that he received a call. On making call, he has been informed. Now, call had been made by FBB. Now, let us see this information which had been conveyed to him. This is the information which is conveyed to him.
Yes.
What lacking is regarding the suspect delivery of the narcotic by the suspected Pakistani fishing boat in position so and so, ship alter her course and reach the shore. So he did not say it. That the Pakistani boat is going to give the delivery of IFB, Indian fishing boat. That is not the information. She found no fishes about in this area of the vessels. Oh, sorry, I'm reached the country 20-30 hours, taking all the precaution as in darkness state. While on reaching the datums, ship found no fishing boat in the area by visual as well as by radars. So on 28th, when they received the call, pursuant to that call, which providing them the exit place in a sea where the vessel is, because he has given position of 279 Mithaport light and 3070 to narcotic miles to the ship alter. So question is now, they went there, but they did not find any ship there. On 20th, they do not find any ship. Then again, after leaving five full lines, 28th May 19, on 21st May 19, ship sighted at Pakistani fishing boat was in radar as well as visual at about 9:15 hours in the ship altered her course. Sir, I do not want to be entered into this because this is in respect of the Pakistani's boat, which I am not representing admittedly. But the word had been used by them for saying that boat. Visualize means it is at the distance which you can see by bare eyes. There was no need of radar can be used, which cannot be visualized. To understand the nearness to the it. Now, so far this, my question is concerned, my lords, then I will be para 6 of his deposition, page 5.
Yes.
I am being sub para 6 में 3-4 लाइन छोटी न वांचू છું.
Fourth line.
I am being shown page number 349
349.
of volume B, annexure B, and thereby state that the information that was received by me from the regional headquarters, Gandhinagar, for further disposal of a Pakistani fishing boat along with the crew and narcotics. Now, this is, Your Honor will be see it. This is not in respect of the information received under section 41(1). This is in respect of after being the custody of that Pakistani boat had been taken. What direction had been given to them by the Director of General? That is what even from the document itself will be APS, and he also had written. That was the direction given. Sab a sab, my friend has also drawn my lord's attention to this letter also. But I'm just disclosing at this stage. I will be read my part of evidence, but just to bring Your Honor, my case is that on 19th Fifth, Your Honor, see that they are coming with the case on 21st May. Pakistani boat seized. There is their question. That after they searched the Indian boat and taken both the boats to a harbor, Oka, or wherever it is. My case is, my defense is my loss, that I had been taken on 19th May at harbor, 2 days prior to this incident.
Number 7. Your client.
My client. The entire vessel has been taken by them on 19th. That is my defense.
Your defense.
Now look at this letter also, which gives some corroborations to my defense also. Sir, this letter is written on 19/5/2020. 21. I do not know why 21. But my case is, I have taken the defense. I am taken on 19.
Accused 1 to 6 have taken as 10. This is of the year 21. Because
it appears so. It appears also. But how? Sab, ek baat નથી કે તમે કહો કે 21/5/2019 ના રોજ તમે દરિયા ઉપર આ બે વહાણ પકડ્યા અને એ ઇન્ફોર્મેશન તમે ત્યાંથી એરએનજી પરથી ડિરેક્ટરને આપો અને ડિરેક્ટર તમને એમ કહે કે તમે આ બે વહાણોને આ રીતે આ જગ્યાએ લઈ જાઓ. That is what this information is. I'm just reading this information. સબ એની અંદર એ ઇન્ફોર્મેશનમાં નીચેથી ચોથી લાઈનથી જરા આપણે વંચાય એવું છે ને સમજાય એવું છે. Arrange to escort apprehend park fish boat of Jakhau along with C408 in company. Jakhau to release concerned agencies, concerned department, so and so. Now, this information, सब एक तो डेट में तो आपने जो मोटा ये लागे છે, પણ આ जो information હોય, तो this is in respect of only Pakistani boat. મારી બોટ પર જો ત્યાંથી લાયા હોત તો એની બી ઇન્ફોર્મેશન એમને જો પકડી હોત તો ઇન્ફોર્મેશન ત્યાં ગઈ હોય ડિરેક્ટ કે વી હેવ સીઝ્ડ ઓલ્સો ઇન્ડિયન ફિશિંગ બોટ, પણ કશું નથી ઇન્ડિયન ફિશિંગ બોટ. અને હું સાહેબ આવી છે મારા ડિફેન્સમાં બી એનું કે અમને ક્યારે એ લઈ ગયા છે ને કેવી રીતે લઈ ગયા છે. that even he was cited as a witness who had been examined as a defense witness by me. So I've been just reading this deposition in respect of this 49 on page 5, paragraph 6 of his deposition, that I am being shown to 349 volume of BB, thereby state that the information that was received by me from the regional headquarters Gandhinagar for further disposal of the Pakistani fishing boat along with crew and narcotics, we received the message decoding language by the radio operators that has been transferred to plain language has been signed by message. So whatever it is, because it is not concerning to me, I'm there, so I'm not much discussing it. But admittedly, okay, they have informed to the higher authorities regarding the Pakistani fishing boat. Direction has been given to them to take the fishing boat by escorting it to the Oka port only. Now, that objection had been raised by friend in the section 65B of Evidence Act will be dealt by my lord because he has already argued on that points. I don't want to be touched with him. Now, I am being shown B, paragraph 8. I am being shown the page 353 to 402, volume B, annexure E, which is the first information report handed over by the DRI, handed over to DRI, Gandhinagar, and the same has been signed by the Assistant Commandant Tanju Biswal as per my instruction. I identify the signature of Tanu Biswal. Then the photograph of this Medina, that is a Pakistani boat, I am not concerned with it. Now, my friend has already argued that this had been wrongly exhibited, but that will be his. So far, number 1 to 6 accused are concerns. I am being shown for 408 volume, paragraph 10, were signed by the Gaurav Sharma, Assistant Commander, the regular officer on behalf of me. Be hereby exhibited as collectively 51, all the good documents 51, 52, true copies. Now, the importance of this witness is concerned, my lord. I am not entering to everything of his deposition, but where his evidence lose the credibility. How this witness, whatever he has deposed, again, I'm Pakistani or Indian, losing his credibility in the sense that if you read from paragraph 15, my lords, maybe, the entire chief examination, जैसे साहब, in chief examination, para 15 yes. એ વાત ખરી છે કે ઇસ એડમિશન NIA રૂબરૂ મારા નિવેદનમાં પછી the entire statement is up to your honor BBC on page 11 and the before beginning of paragraph 16. The entire chief examination, as a matter of fact, ની હકીકત લખાવેલ નથી. Then again, your lordship may turns to kindly turn to paragraph 17 on page 12.
Yes.
Para 17, page 12. એ વાત ખરી છે કે મેં એનઆઈ રૂબરૂના નિવેદનમાં the entire his deposition. Then above paragraph 18 on the end of paragraph 17 on page 13 ની હકીકત લખાવેલી નથી. So and further he admit regarding those documents he has placed on record 49, 50 and 51 that he has placed on record, apart from whether they are under the law admissible in evidence, can be exhibited or not, that issue will be remain, my friend, and argue that point. But para 18 એ વાત ખરી છે કે આ 49, 50 અને 51 માં રજૂ થયેલા દસ્તાવેજો મેં એનઆઈએ ને સોંપેલા નથી, તેમજ મારા નિવેદનમાં પણ ત્રણે દસ્તાવેજો બાબતે મેં કોઈ હકીકત જણાવી નથી. This is important. Why, my lord, the doubt is created? Doubt is created to the document itself. Because this is the statement કે આ નિવેદનમાં પણ મેં ત્રણે દસ્તાવેજો કોઈ હકીકત જણાવી નથી. That facts which had been narrated in this document had not been disclosed by him, which are important facts that he is admitting. Secondly, those documents, they are not the original. They are not the original. All true copies they have produced. I do not know from where the true copy has been. If they can do the true copy, why the original is not producing before the court? So this creates a serious doubt. Everything had been subsequently developed and the dates and everything had been set and the complaint had been lodged. That is what appears from their deposition itself. હવે સાહેબ આ સાક્ષીને page 14, para 20. Para 20.
Yes.
So, ये हकीकत કેટલીક creating doubt, suspicious. My lord is aware of the facts that the settled law of a criminology is that if witness is completely trustworthy, the court can rely on him. If it is completely unreliable, the court can take the decision this way. Completely reliable, can take this way. But if he is neither completely reliable nor completely unreliable, then naturally the court should see that his statement should be corroborated by some evidence. Now, this is what I'm saying, that para 20 એ વાત ખરી છે કે ડીઆરઆઈ ઓફિસ કે ડીઆરઆઈ ના અધિકારી મને કોઈ લિખિત મંજૂરી ઓપરેશન કરવા માટે મળેલી નથી. સાહેબ સ્વેચ્છાએ જણાવે છે કે રિજિયનલ હેડક્વાર્ટર તરફથી અમને માહિતી મળતા અમે ઓપરેશન કરેલ છે. એ વાત ખરી છે નથી કે સીપ ઉપર એક કરતા વધારે કમાન્ડિંગ ઓફિસર, એ વાત ખરી છે કે ઓપરેશન કરવા માટે કોઈ લિખિત પરવાનગી રિજિયનલ હેડક્વાર્ટરથી મળેલી નથી. સાહેબ સ્વેચ્છાએ જણાવે છે કે રિજિયનલ હેડક્વાર્ટરથી મને સિગ્નલ જે આ 49 થી રજૂ છે તે મળેલ છે. That 49 is not, I'm giving him a direction. Now, so far my issue is concerned that 41, 42, I'm arguing, that will be fine in para 22. એ વાત ખરી છે કે અમો ઇન્ડો પાકિસ્તાન બોર્ડર પર જે ગુપ્ત માહિતી મળેલી તેના અંદર ઓપ્શન કરેલી, તે ઓપરેશન કર્યા બાદ તે માહિતી ગુપ્ત રહેતી નથી. કોઈ પણ માહિતી સી પર મળે અને તે મહત્વની હોય તો તે માહિતીની નોંધ કરવાની થાય ત્યારે હું કરું છું. Sir, I am taking his admission. His admission to the effect કે અહીંયા બી એમને કીધું કે અમને જે આ માહિતી મળી in respect of the serious offense. It was a serious offense. The information which was received by him. તો એ ઓપરેશન કરવાની ગુપ્ત માહિતી મળી એમને મળી હોય તો એ મહત્વની હોય તો માહિતીની નોંધ કરવાની થાય ત્યારે તે હું કરું છું. તો એની નોંધ કોઈ જગ્યાએ એને કરેલી હોવી જોઈએ. કઈ માહિતીની નોંધ કરવી, દસ્તાવેજો તૈયાર કરવા તે માટેના નિયમો છે તે કસ્ટમ એક્ટ ને એનડીપીએસ એક્ટ નીચેના છે, તેનું અમે પાલન કરીએ છીએ. એ વાત ખરી છે કે ચોક્કસ નિયમ કે કલમ હું કહી શકું નહીં. રિજિયનલ હેડક્વાર્ટર અને ડિસ્ટ્રિક્ટ હેડક્વાર્ટરમાં જાણ થાય છે. ડિસ્ટ્રિક્ટ હેડક્વાર્ટરની દરિયામાં જવા માટેનો ટાઈમ નોટ કરી અને તે ઓર્ડરમાં કયા વિસ્તારમાં પેટ્રોલિંગ કરવાનો હુકમ થાય છે, ત્યારબાદ તે શિપ જવા માટે નીકળે છે. દેન પેજ 15 after leaving 2-3 લાઈન એ વાત ખરી છે કે માહિતી મેળવનાર અને માહિતી મોકલનાર બંને પાસે દસ્તાવેજો હોય છે. એ વાત ખરી છે કે અમે જે માહિતી મોકલેલ તેના દસ્તાવેજો અમારી પાસે છે. એ વાત ખરી છે કે મારી પાસે મળેલી માહિતીના દસ્તાવેજો મેં કોઈ ઓથોરિટી પાસે રજૂ કરેલા નથી. I am saying that those documents original are not available. That is not the case. That is not the case because he admitted કે મળેલી માહિતીના મોકલેલા બંને દસ્તાવેજ હોય છે. એ વાત ખરી છે કે અમે જે માહિતી મોકલેલા તેના દસ્તાવેજ અમારી પાસે છે. એ વાત ખરી છે કે મારી પાસે મળેલી માહિતીના દસ્તાવેજ મેં કોઈ પણ અધિક્રમે રજૂ કરેલા નથી. તો એની પાસે તો છે. પછી why that original are not coming on record? Then para 25 અમારી શિપ બહારની દુનિયા સાથે સંપર્ક રાખવા VHF, HF અને FBB ના સાધનો હોય છે, જ્યારે અન્ય સંપર્ક માટે નેવીના સાધનો વાપરીએ છીએ. એ વાત ખરી છે કે નેવી સાથેના સંપર્ક માટે નેવીના સાધનો વપરાય છે. જે કોઈ માહિતી અમને VHF, HF કે FBB દ્વારા મળે તેનું કોઈ રેકોર્ડિંગ થતું નથી.
Yes.
So question is first again I've been coming up that he is saying a chief examination. The information he has received from the director of revenue on call કે જેનો કોઈ રેકોર્ડ રહેતો નથી એને કેવું છે. કોલ કરે કે તેનો કોલ કરી નોંધ કરીએ છીએ. ચીફ ઓફિસર ઓપરેટરને લોગબુક મેન્ટેન કરે છે. એ વાત ખરી છે કે એનઆઈએ રૂબરૂના નિવેદનમાં આવા કોઈ દસ્તાવેજો એનઆઈએ ને સુપ્રત કરેલા નથી. I'm not on this because this is to be witness and about this question I did put. Whether you have produced or not. But at the same time, the burden is otherwise on the investigation officer. While he investigating the officer, the requisite documents which supporting the prosecution case ought to have been collected by him. He has also not collected. This man has also not produced. અમે જ્યારે શિપ ઉપર માહિતી મળેલ અને તેની જાણ રિજિયનલ હેડક્વાર્ટરને કરેલ તેના દસ્તાવેજો શિપ ઉપર છે અને તેવા કોઈ દસ્તાવેજ કોઈ પણ ઓથોરિટી રજૂ કરેલા નથી. So it is not so that that document. One thing is certain. From this evidence you can read it, like we understand. Presuming that he is right, you see, these are the documents available to them. If these are the documents which he referred that of the same nature, of the same, the original one, non-production of that documents creates serious doubt whether that document is in the same nature of their producer by putting a true copy, by doing a true copy, they are of the same nature or not, creating serious doubt of it. એ વાત કરી છે કે મને કોઈ પણ ઓથોરિટી કોઈ દસ્તાવેજ રજૂ કરવા જણાવેલ નથી. આવા દસ્તાવેજો મેં તૈયાર થયા છે તે કોમ્પ્યુટર ટાઈપ રિટર્ન છે. તેના પર અધિકારીની સહી થાય છે અને જે કઈ માહિતી મળે છે તે પ્રથમ હું હાથે લખું છું, ત્યારબાદ તે ટાઈપ થાય છે અને ત્યારબાદ કોમ્પ્યુટર કોપી તૈયાર થાય, ત્યારબાદ રેડિયો ઓપરેટર પાસે જાય છે અને ત્યારબાદ તેને કોડ લેંગ્વેજમાં તૈયાર કરવામાં આવે છે. None of these document which he refer had been produced to show that the information had been received by. Now para 29 માં સાહેબ એને એક સવાલ પૂછવામાં આવ્યો છે પણ એમાં જે મહત્વનું છે સાહેબ 41 અને 42 જે મહત્વનું છે સાહેબ એને હેડક્વાર્ટર સવાલ છે પેરેગ્રાફ 29 માં કે હેડક્વાર્ટર થી મળેલ C408 અને C447 એ સાહેબ ખોટું લગાવ્યું છે. 37
408 અને 437
માં સિગ્નલ નું રેકોર્ડિંગ થાય છે કે કેમ? સાહેબ એના જવાબની અંદર એને એવું કીધું છે કે અમે સિગ્નલ મળે તે એબીપી ના માધ્યમથી મળેલા ન હતું અને સિગ્નલના મેસેજ 3 મહિના સુધી રાખીએ છીએ અને ત્યારબાદ તેનો નાશ થાય છે કારણ કે સિગ્નલનું આયુષ્ય 3 મહિનાથી 6 મહિનાનું હોય છે. આઈ એમ ટેક ઇટ સાહેબ એઝ ઇટ ઇઝ, ટેક ઇટ એઝ ઇટ ઇઝ કે that the life of that record will be 3 to 6 months only. But the investigation officer could have collected that. You cannot escape from your liability of producing those documents under the guise that because their lives is 3 months or 4 months. સાહેબ આપણા ત્યાં દાખલા તરીકે હોય ABCD આપણે જે બાયફર્કેટ કરીએ છીએ આપણી ફાઇલોને, પછી એમાંની ડી ફાઇલ હોય કે ભાઈ 6 મહિનામાં નાશ કરવી, અમુક 2 વર્ષ પછી કરવાની, અમુક 10 વર્ષ પછી કરવાની, પછી 6 મહિના થઈ ગયું એટલે તમે નાશ કરી નાખી. પણ એ 6 મહિના પહેલા તો ઇન્વેસ્ટિગેશન થયું તો એ કાગળ તો આવે કેમ? હવે સિગ્નલ મળ્યા બાદ તેની પ્રિન્ટ પણ લઈએ છીએ અને પ્રિન્ટ પણ 3 કે 6 મહિના બાદ નાશ થાય છે. આ સિગ્નલની પ્રિન્ટ 3 મહિના દરમિયાન ઇન્વેસ્ટિગેટિંગ એજન્સીને આપવાનો મેં કોઈ પ્રયત્ન કર્યો નથી કારણ કે મેં તે જરૂરી ન હતું. સાહેબ આ શબ્દોને જો આપણે પકડીએ કે એને નથી રજૂ કર્યા બીકોઝ એ જરૂરી ન હતા. lead us to believe rather, or we can assume these things or presume rather that those documents were not relevant for the purpose of proving the case against the accused, and therefore it is not. So you can't blow hot and cold that these have been maintained this way, we are keeping the record. VH થી જ્યારે કોઈ અમારો સંપર્ક કરે ત્યારે અમે ત્યારે તેનો કોઈ રેકોર્ડ રાખતા છીએ કેમ તે પૂછે છે. I am not relevant my lord. Yes, this is relevant. VH થી જ્યારે અમે VHF થી જ્યારે કોઈ અમારો સંપર્ક કરે અથવા અમે કરીએ ત્યારે તેનો કોઈ રેકોર્ડ રાખીએ છીએ કે કેમ તેવું પૂછતા સાહેબ જણાવે છે કે અમે તેવું કોઈ રેકોર્ડ રાખતા નથી. VHF HF ના કોમ્યુનિકેશન થાય છે કે કેમ તે બાબતનો કોઈ રેકોર્ડ રાખવામાં આવે છે કેમ તેવું પૂછતા સાહેબ જણાવે છે કે અમે કોઈ રેકોર્ડ રાખતા નથી, અમે તે લખી લેતા નથી. એટલે none of the message they have received either through VHF or HF, there is no record with them. અમે કોઈ રેકોર્ડ નાખતા નથી, તે લખી લેતા પણ નથી. VHF HF કોમ્યુનિકેશન થાય છે કેમ તેવું ઇન્સ્ટ્રુમેન્ટ ઉપર રિફ્લેક્ટ થાય છે કે કેમ તેવું પૂછતા સાહેબ જણાવે છે કે ચેનલ નંબર ડિસ્પ્લે થાય છે. મેસેજ ડિસ્પ્લે થાય તો સાહેબ એની કોપી પણ નીકળે. જેના પર ચેનલ નંબર આધાર છે મુંબઈ, પોરબંદર, ઓખા અને દેન એ વાત પેરેગ્રાફ 31 એ વાત ખરી છે કે VHF થી જે મેસેજ મળે તેની લોગબુક CDR મેન્ટેન થાય છે. FFB થી જે મેસેજ મળે છે તેની કોઈ વિગત લોગબુકમાં લખાતી નથી. અમો જે સિગ્નલ મળે છે તે કોડ લેંગ્વેજમાં હોય છે. ગાંધીનગર હેડક્વાર્ટરથી અમોને પાકિસ્તાની બહુવાર જે મેસેજ મળેલા This is important. એ મેસેજનો કોઈ રેકોર્ડ રાખેલ છે કે એમ તેઓ પૂછતા સાહેબ જણાવે છે કે મારે તે જોવું પડશે, મારે તે જોવું પડશે. કોમ્યુનિકેશન ઓફ ધેટ 46. મેં આપ સાહેબને બતાવ્યું કે ફેક્સ થી હોય તો ડોક્યુમેન્ટ એવિડન્સ હોય, જો પોસ્ટ થી મોકલેલું હોય તો એનો એવિડન્સ હોય સ્પીડ પોસ્ટ, અને જો કોલ થી ઇન્ફોર્મેશન કરેલું હોય તો એના કહેવા મુજબ એ મેસેજ રેકોર્ડ રાખે છે. તે જણાવ્યું છે કે તે જોવું પડશે, એટલે એને જોવું નથી, એ રજૂ થવું નથી. એ વાત ખરી છે ગાંધીનગર કોર્ટે હમ પાકિસ્તાની બોર્ડ બાબતે જે મેસેજ તે મેસેજમાં મેં કોઈ ઇન્વેસ્ટિગેશન એસીને આપેલ નથી. સો એ એડમિટી કે આવા કોઈ મેસેજ એને મળેલા તે એને ઇન્વેસ્ટિગેશન ઓફિસરને બી સોંપેલા નથી. Then in the bottom of this paragraph, ગાંધીનગર રેકોર્ડથી અમને પાકિસ્તાની બોર્ડ બાદ જે મેસેજ મળેલા તે મેસેજનો સમાવેશ થાય છે કે કેમ તેવું પૂછતા સાહેબ જણાવે છે કે તેઓ મેસેજ 850 કે 51 સાથે સામેલ નથી. પછી મેં એમને 49 વંચાયું છે, આપને મેં અગાઉ વાંચી લીધું છે, એ આખું રિફર કર્યું છે એ પેરેગ્રાફની અંદર, કે એની અંદર તો એવું કહેવામાં છે કે આ બોર્ડ તમે ત્યાં લઈ જાઓ. એ વાત ખરી છે કે 49 સ્થળે રિસીવ મેસેજ લખેલા છે અને રિસીવનું ડેટા 19/5/21 ટાઈમ 11:01 દર્શાવે છે. એ વાત ખરી છે કે તેમાં હાસ્યાની અંદર સહી છે તે સહી મારી સહી છે. એ વાત ખરી નથી કે સહીની નીચે જે તારીખ નાખેલ છે તે 20 નાખેલ છે, મહિનો વંચાતો નથી અને સાલ 2019. એટલે એ લેટર સાહેબમાં તારીખ 19/5/21 છે. એને રિસીવ કર્યા અંગેનું એને જે પોતે જે શેરો કર્યો છે એમાં 20 લાખ તારીખ લખી છે, પણ કયો મહિનો છે એ વંચાતો નથી, પણ 2019. સાહેબ આ જો આને જો તમે આપણે સાચું માનીએ, ધીસ ઇઝ ટ્રુ બીકોઝ ઇટ ઇઝ પ્રોસિક્યુશન કેસ, કે મેં 849 નો પત્ર આરોપ આ સારી નંબર 2 ને 20મી તારીખે 2019 માં મળ્યું છે. મહિનો આપણે જવા દઈએ સાહેબ, એને મહિનો નથી કીધો, 5મો પણ it is certain that it has been received in 2019. It is certain on 20th he has received this. So this letter which has been written to him, that is in respect of taking the Pakistani board to harbor, which according to them they will seize on 21st. તો 20મી તારીખ તો શક્ય નથી. 20મી એમને પોતે જો 20મી તારીખ નાખી તો 20/5 તો શક્ય નથી સાહેબ. હું એટલા માટે સાહેબ કહું છું કે આ ઓલ ધીસ ડોક્યુમેન્ટ્સ એક આખા પકડાઈને લાયા જે કંઈ કર્યું હશે તે બધું બરાબર, but thereafter everything story had been arranged and then the papers have been created. This appears so. સાહેબ સ્વેચ્છાએ જાણે કે તારીખ 28/8/19 છે, but that is impossible. જો એ કહેતો હોય 28/8/19 છે તો ઇમ્પોસિબલ, કારણ કે તમે તો 21/5 ના રોજ પકડી.
Yes.
એટલે there's message which had been received. Then the important for this purpose is the position of PW number 3, 58 exhibit.
For the purpose of section 42.
Pardon?
For the purpose of section 42.
I'm 42, 142, 2 only I'm arguing. સર મેં આટલા માટે જ આપને બતાવ્યા છે.
42, how many witness you are going to refer?
Well, these all witnesses, both 2-3 witnesses more will be there, but will be very short. One here or there.
Remaining on the next date.
Remaining, I'm disclosing my note. I'm apart from my defense that on 19. આપણે એમની સાથે સાહેબ ચાલીએ એઝ પ્રોસિક્યુશન કેસ કે મને 21 મિનિટે લઈને આવ્યા. મને ઇમ્પ્લિકેશન કરવા માટેના સાહેબ 3-4 એમને કારણો આપ્યા છે. એમાં એક કારણ એવું છે કે there was a code word used between these two things. પેલો code word જે વાપરે, that code word had been given by the Pakistani. કે હું આ code word વાપરું ને મને સામેથી આવો જવાબ આવે એને મારે ડિલિવરી આપવાની હતી. તો one thing, connecting evidence is a code word. Second thing એમનું એવું કહે છે કે હું ત્યાં લાંબા સમયથી ફિશિંગ કરતો હતો, મારી પાસે કોઈ ફિશ મેં નથી કરી, મારી નેટ ક્લીન છે, બરાબર, અને મારા કપડા ક્લીન છે ક્રૂઝના. આ 4 કારણોથી મને ઇમ્પ્લિકેટ કર્યું છે કે પ્રિઝમ્પશન ઉપર કે મને ડિલિવરી આપવાના છે. અને એ 4 મુદ્દા ઉપર જ હું સાહેબ આપ સાહેબને બધો એવિડન્સ પછીથી વાંચીશ one by one. But today I am on because this is the main point.
For all.
To effect the entire case.
For all. For everyone.
To everyone. And more particularly, I am reading that in one message they disclosing that they have to deliver at fees. પણ કોને એ નથી. સેકન્ડમાં તમે જોશો તો આમ કે ઇન્ડિયન ફિશિંગ બોર્ડને આપવાના છે. થર્ડમાં આવશે તમે તો એવું કહેવું છે કે એની ખબર નથી, ખાલી એટલું જ છે કે ત્યાં આવવાના છે. આપ પોતે ચાલુ રાખો, નહીં તો ડેટ આપશો તો મને વાંધો નથી.
Date જ આપો.
નો પ્રોબ્લેમ, નો પ્રોબ્લેમ.
પહેલી આપણે પહેલીમાં શું? આવી જ જવા જોઈએ. પહેલી બીજી પહેલીમાં છે, બીજી પહેલી તારીખ, પહેલી 1st
of February.